Welcome to the Go Big With Gib podcast, a place for professionals, business owners, and entrepreneurs to talk about their big wins. On this episode of Go Big With Gib, we've got Harry Albritton here with us. We talk about his career achievements and the big wins that he's had over the years. Harry is a partner at Irons & Irons, and he is the head of the personal injury and medical malpractice department. Harry, how are you doing today?
I'm doing great.
Great. It's great to have you on. Tell us a little bit about yourself.
Well, I'm married. I have 3 sons, ages 19, 16, and 13. I've been an attorney now for almost 22, 21 years in that range right now. I'm a 1998 graduate of East Carolina University, so go Pirates. After undergraduate, I majored in psychology with a minor in business, and I was unsure of what track I wanted to take, whether it was going forward into clinical psychology or potentially law. And so I decided I wanted to figure out, before I invested all that money in either track, which way I really wanted to go. And so I applied to a number of law firms in town, as well as trying to get internships with psychologists. Well, no psychologists were willing to take on an intern. And so a couple of law firms offered me a position. And one of those offers was a local law firm in Greenville, and I took that opportunity. And that gentleman encouraged me to follow in his footsteps, actually, and practice law. And that's what brought me into the legal profession.
Had you always known that you wanted to be an attorney, or was that something that developed at that specific time when you were looking for jobs in Greenville?
It'd been something that I had thought about for many years, even before college. When you're asked as a child, what do you want to be when you grow up? And I frequently had said, I want to be a lawyer, not really knowing what it entailed. But so it was always in my mind. And when I was in undergraduate, I took a couple of legal classes that interested me. And so I figured when I graduated with an undergraduate degree, I had to make a decision. And really that's what pushed me into finding out for sure this is what I wanted to do. And so that was applying and basically knocking on doors until someone would let me work with them.
Let's talk a little bit about that first opportunity that you had. Tell me a little bit more about how that went initially, how that first started.
Well, it's actually quite interesting. There were 2 local law firms in Greenville that offered me a position. One that did predominantly transactional law. They did real estate transactions, wills, trusts, and that sort of thing. And there was another that did personal injury work, and they did high-end personal injury work, complex cases where they traveled all around. At that time, I didn't know the difference, really, what lawyers did. I didn't know there were really kind of specialties or anything like that.
Right.
The transactional law firm wanted me to work a certain schedule that I couldn't actually work due to class obligations. The personal injury attorney said he would be flexible and work around my class schedule. I had one more class to finish before I could graduate. And so I took the job that allowed me to finish and graduate on time and still work. And that ended up being with Marvin Blunt Jr. Marvin Blunt III, his son, is a practicing judge now in Pitt County. But Marvin Blunt Jr. gave me my first opportunity. And it was the rock bottom at his office. I mean, from copying papers to running to the courthouse to going and get laundry, whatever it may be, I did whatever he asked. And I stayed with him for almost a year and a half. Okay. And at that time, I'd seen enough that I was interested in pursuing this as a career. And I sat down with Marvin, and I listed all the places that I could potentially go to school. And he didn't seem interested in any particular school. I was accepted to a university in Ohio. And they offered me a scholarship. And I met with Marvin because I respected everything that he had to say. And I said, what do you think about me moving to Ohio and taking the scholarship? And he encouraged me. He said, take that scholarship. He said, I don't care where you go to school. When you get out, you're coming to work for me. And that gave me a sense of confidence and took a lot of stress off of going to school and incurring all of the debt of going to law school, knowing that I had an offer already to work when I got out. And so I went to Ohio.
And tell me the name of the school again.
Ohio Northern University. It's a small town in northwest Ohio, real small campus, just a few thousand kids in undergraduate and in their graduate programs. And they offered me an opportunity to go up there and on their dime get a law degree, which I took them up on that opportunity. And it was a great experience. Not only did I meet my current wife, but it gave me a good idea of really what areas of law I wanted to practice as well. So I took the opportunity in law school to work for other law firms in the area of Ohio, doing criminal work, doing some transactional work, and realized that my heart was really in North Carolina and with personal injury work.
You got your undergraduate degree from East Carolina University. Was that 1998?
Correct.
Okay. During I guess you had one more class to finish it at East Carolina University before you could go off to law school.
Correct.
And during the time that you were finishing that one course, you were working with Marvin.
That's right.
You said you were with him about a year and a half?
I did, because I worked with him while I was still in school, and then for that next essentially calendar year, and I started law school in 1999.
When you were there, were you doing straightforward gopher type stuff up until law school?
No, it changed. It changed dramatically over that year and a half. And for the first several months, all I did was the gopher role and the copying papers and filing and that sort of thing. And as time went on, I started drafting documents. And he let me read things that he had drafted so I could emulate some of the things that he had done. And he had me drafting discovery to go out to potential defendants, and he had me drafting complaints. And so I started from having no desk, no office, other than just roaming around from one office to another, asking what I could do to help, to having my own desk, my own little space, to actually do production and do work on individual cases. He was working on some class actions at the time as well, and so I got heavily involved in that aspect before I went to law school.
And it sounds like during law school you worked for different types of firms in different practice areas, and those were all based out of Ohio. So rather than come back and do summer clerkships, as they call them here in North Carolina, you did experience some different things throughout your law school career in terms of jobs.
I did, with the exception of the summer before my final year. I'd reach back out to Marvin to find out how things were going, and we kept in contact. And so we would call each other every once in a while and see how each other were doing in their respective roles. And so he asked if I was interested in working for him over the summer, that they had some very big cases that were going on, and if I had any interest in coming down to assist. And I said I did. I accepted that responsibility and came down, and he did. He had some very large cases that I was able to work on as an intern. And then after my third year and after I passed the bar, those cases were still going on, and I was able to have the opportunity to do that as well.
How many people were in Marvin's office at the time? What was the dynamic there? Were there other attorneys there? Or was just you and Marvin, or were there several attorneys in the office and support staff members? There
had always been other attorneys there. Initially when I was with Marvin, I believe he had 2 other lawyers with him. And then when I came back for the clerkship, I think he had added 2 additional. And so there were a total of 5 attorneys at the firm when I was doing my clerkship.
Where was his office located at the time?
It was at the end of First Street, right on the river, downtown Greenville. He had a building that was a 1-story building. It was a large building, but it was a 1-story building that overlooked the river. And
kind of down near the town commons.
Right next to the town commons. I believe it is now a student housing, one of the little high-rise student housing developments down on First Street. But at the time, it was a 1-story building. When you walk into the building, the left-hand side were Marvin and his staff members. The middle of the building was the conference room. And the right-hand side, when I initially worked for him, were other attorneys, a different law office. In fact, a local attorney, criminal attorney, Les Robinson, rented space over there when I was clerking I was working for Marvin before law school. But by the time I got back from my first 2 years in clerking, he occupied both sides of the building, had staff in both sides, and it was a much different feel compared to when I was there before.
Why do you think Marvin took such an interest in you? What do you think it was that he saw in you that made him think, I'm going to spend some extra time with this young man and try to help bring him along?
I think it started from the very beginning. This was back before the internet was really heavy. We didn't have cell phones. We didn't have those sorts of things like we have now. And so I was knocking on doors. And so I was writing letters and then following up with telephone calls and then stopping by. And so I was very passionate about trying to get my foot in the door at any law firm. And so I made contact several times before he was willing to actually meet with me. And then when he hired me initially, I wore a suit and tie every day. And so I was the only person wearing a tie in the office every day. And he had said something to me very early on in the interview process about going over to the courthouse. And Marvin had a rule that if you go to the courthouse for any reason whatsoever, you have to have a tie on. And so I didn't know whether at any given time I was going to be asked to go to the courthouse for anything. Sure. And so I wore a tie every single day. And I knew that at any time if he needed me to go to the courthouse, he wanted me to be in a tie. Now, I didn't realize then it didn't really apply to me. It applied to the attorneys in the office. But I acted in that role that I would do whatever he asked me to do. And I was very passionate about trying to learn. And so at any given time, I'm sure I was a pest as well, but I wanted to be involved. I wanted to can I watch? Can I read what you've done here? And so at any moment I had that I didn't have a task to do at his office, I was reading something he had written, or I was sitting in on a meeting, or if he had to go to the courthouse for one reason or another, I wanted to follow him over there. And so I think that was it, that he knew I was eager to be a sponge, basically, and take on whatever he could give me.
Let's talk a little bit now about when you graduated law school, you passed the bar, you returned to work for Marvin. Tell me a little bit about that.
Marvin threw me right in. I mean, it was like I had been practicing for years almost in his mind, and I did not have even a true grasp of what it was like being an attorney. But it was just moments, really, after I knew I was a licensed attorney that I was taking my first deposition. And I didn't even know what a deposition was. Marvin gave me a copy of a transcript of a deposition that he had taken in a similar case from years ago. He put me on a plane, and he sent me out there to take a deposition and to read the facts of the case as I was going. Now, at the time, it was the biggest thing I had ever done in my entire life. When I realized, looking back on it, it meant nothing to the case at issue. But for him, it was a big step to let me go do something like that on my own. And so he threw me right into it. I passed the bar in August of 2002. I think I became licensed in early September. It was all around a couple of days of each other, September of 2002. And in January of 2003, I was in my first trial with Marvin in Charlotte, North Carolina. And it was, to this day, the biggest trial that I've ever been a part of.
He really threw you into the fire, so to speak, which we've had the opportunity to work with some young lawyers, and I think we've kind of brought them along in a different manner. I don't think we didn't give them that much responsibility straight out the gate, but we also didn't, they were given more guidance and more of an opportunity to kind of, build some confidence doing something that's easier. And then, increasingly, we gave them more increasingly difficult assignments after they proved themselves on simpler things. Tell us a little bit about that first big case that you worked on that turned out to be such a massive case that still is one of the biggest cases you've worked on, or maybe the biggest case you've worked on in your entire career.
So in May of 2000, while I was in law school, there was a race over at the Charlotte Motor Speedway. And after the race, the fans were leaving the track and going back to the parking lots and going back to their cars. And there was a bridge that went over one of the highways there in Concord, North Carolina, right outside of Charlotte. And so it was a pedestrian bridge. And so we had this massive amount of people walking from the track to the parking lot over this pedestrian bridge. Well, the bridge was full of people. The bridge was only a few years old as well, and it collapsed. And it was many feet up in the air. And as it collapsed in the middle. And people from both sides fell into the middle. And so you're talking about hundreds of people that were injured, some extremely severely injured. Marvin represented, I believe it was 16 people that were injured on that bridge. He represented more people than any other plaintiff attorney in the state of North Carolina and in Virginia and in West Virginia and in South Carolina, who all had some role in what was going on. And that was a testament to who he was. He was so well known throughout the entire state at handling large, complex cases that he got a lot of clients that way. And so he represented more people than anybody else. And not only because he had more clients, but he had a ton of clout as well. He got named the co-chief of the steering committee to handle all of the discovery and basically the trial of this massive case against the track, as well as some of the contractors who were involved in building that bridge. And so that was the first trial. And we were basically representing a family, but we were representing everybody who was involved in that, because we were tasked with the responsibility of finding out who was at fault and having a jury make that determination. And so we started in January, and I say I moved, and that's the way it felt. I moved to Charlotte, and the case was tried in Mecklenburg County, and I lived in a hotel for 9 weeks during trial.
Wow.
And we worked 7 days a week, 14 to 16 hours a day, and it was constant. And I say it went on for 9 weeks. There was 9 weeks of actual being in the courtroom, having witnesses, thousands and thousands of exhibits, probably 30 to 50 witnesses that had to testify in one form or fashion. And so the lead up to that trial, I started again in September of 2002. I focused everything, my entire months until January, on that case. There was so much information. But I'd worked on it when I clerked for him over that summer, too, before my last year. And so, you know, and Marvin knew my work ethic. You know, when I started working for him as an attorney in 2002, I'd already had 4 years with him in one form or fashion, meaning he'd known me for that long. I'd worked with him before law school, 3 years of law school, a summer clerkship with him. And so it wasn't like I was completely green to him either. So he knew what I could do, and he gave me a lot of trust for someone so young. We were, interesting side story, we were in the courthouse, and I was walking the halls, and we had just gotten there for the morning, and I was meeting some of the witnesses in the hallway that were going to be testifying that day, and I saw off in the distance another young attorney, and he and I made eye contact, and there was a familiar face, and he and I had gone to law school together in Ohio, okay, and he started working for a defense firm, insurance defense firm in North Carolina. And we saw each other across the way, and we walked up, and we said pleasantries. And I asked him what he was doing in the courtroom, in the courthouse, and he said, "There's a massive trial that's going on, and my boss wants me to come and watch the attorneys that are involved in that trial." But he said, "You can learn something from the attorneys that are on both sides of this case." Right. He asked me, he said, "What are you doing out here?" And I said, "I'm one of the attorneys in that trial." And it was a neat experience. Again, I couldn't have asked for a better start to my legal career, to be involved in such an enormous case with the responsibility that we had, and again, not just for our clients, but for everybody involved in that bridge collapse. And that case went to a jury verdict, and we were able to recover several millions of dollars for our clients. And not just for those folks. That set the stage for everybody else involved in the case as well.
That was the first case. I think what you're saying is that was the first case of all the people injured in the bridge collapse. That was the very first case to go to trial.
That's
is that
absolutely
right?
Right. Yep.
And what did you say Marvin's designation was in terms of representing the entire group? You called him.
He was the co-chair, the chief of the steering committee. And so the steering committee was a group. So there were dozens and dozens of lawyers who had individual clients. And then there was a steering committee that was set up to basically run things. And then out of that steering committee, they narrowed it down to even more, to 2 attorneys who would be in charge. And Marvin being one of those attorneys. And they were selected by the other attorneys.
So these are all plaintiffs' personal injury attorneys, all really big, well-known firms with guys with huge reputations.
Huge reputations and huge egos. And they all put those egos aside, knowing Marvin's talents, and said, we want you in that role. We want you in the one to try that first case. We want you to be the one in charge of this group to help direct the way this case is going to play out, which was an enormous responsibility. And throughout the years and those months leading up to that, I was one of the attorneys that was going along to all these depositions. And I'm young as can be. I'm the youngest one in the room. Every room I was in, I was the youngest one in the room. And I had that responsibility to go off and do this. And so, I went with Marvin on a number of occasions. Some occasions I went by myself. We traveled all around the country. There were experts and witnesses from the coast of the Pacific Ocean to the coast of the Atlantic Ocean. I mean, it was all over the place. It was such an enormous case. It was one of those cases that every day when you walk out of the courtroom, the press are right there. They're there with their cameras and their microphones right in front of your face, wanting to talk to you about what happened. Not talk to me, talk to Marvin, but again,
Sure.
To be in that atmosphere and to be able to sit, up there with him at counsel table and be a part of that trial was just a phenomenal experience.
Sounds like similar to, being an athlete in a big, professional sports league, or being around that, being able to be around athletes, as they go into the stadium to play in front of 50,000 or 100,000 fans. It sounds like it was a similar atmosphere in that it's a very exciting thing that you don't get to experience that often as an attorney.
Most attorneys, when they get into court and they have to try a case, whether it's a bench trial or a jury trial, there's not a lot of people in the audience. All right, you've got your clients there, and you've got the people who care about that individual case. So they may be a witness here and there, or some family members, whatever. But it's never typically a courtroom that's full of people. Now, we see a lot of courtrooms on TV where it's some high-profile cases, and they're full. But that was this. That was the one on TV every day. This was one that was a report on the Charlotte News every day about what was going on. Every day there were reporters full in the background. There were people that were drawing the sketches of the witnesses and what was going on, and pictures of Marvin and his perfect hair and his tailored suits and all of that. It was a phenomenal experience, and to walk out and have cameras in your faces and flashes going off and microphones in front of Marvin, and him being the perfect professional at every step, only giving what they needed to know and very limited on what he was going to reveal about what we were doing next and what was going to happen the next day. And it was a tremendous learning experience for me of how to conduct yourself publicly, privately, and then in trial. It was a phenomenal experience for someone who's fresh out of law school.
You said that you were in Charlotte for 9 weeks, I believe, that you basically moved to Charlotte for 9 weeks. How long was the trial?
The preparation was actually done in Greenville. And so when it was time to go to trial, we went to trial. And so we had very little lead-up time in Charlotte. It may have been a weekend that we were in Charlotte before trial started on that Monday. So everything we did was in Greenville, in our Greenville office. The trial probably went on, now this is dating me back a couple of decades now, but the trial probably went on about 8 to 7.5 of those 9 weeks. The jury was out in deliberations for probably for a week to a week and a half before they came to a verdict. And
Okay.
so, but every night when trial ended at 5 o'clock for the day, because that's when the courthouse, ended the court for the day, that didn't end our day. Our day was then going to the hotel, meeting in the conference room that we had reserved at the hotel with witnesses for the next day, prepping witnesses for the next day, getting the exhibits ready. It was a tremendous opportunity, but a tremendous workload as well. I mean, it was an exhausting time. I was a newlywed as well.
I was going to ask you about that. I know you said you met your wife when you were in law school, and I assumed you were already married by the time that you tried that case. But how was that? I guess your wife stayed here and you went to Charlotte?
Being that my wife is also an attorney, it helped because she understood the opportunity and she understood the obligations. And so it was difficult because, again, we were newlyweds and I didn't come home. I mean, when I left to go to Charlotte, I drove my little Pontiac Sunfire out to Charlotte, put it in the parking deck at the hotel, and it never left until I came home when the trial was over and the jury had returned a verdict. And so we spoke on the phone, but I didn't have a cell phone and she didn't have a cell phone, so it was all landlines and that sort of thing. But we spoke on the phone most evenings. I would take a few moments before we got back from trial, after dinner, and before we went into the workroom for the remainder of the evening, I would talk to her and give her a rundown of what was happening, and she would tell me what was going on with our remodel of our old house that she was having to take on that responsibility all on her own, unfortunately. But it was a hard experience for both of us, but it was one of those that I think that gave me so much confidence going forward in my career, being able to start off that way and realize that you have to understand we were a small law firm. Okay, we had 5 attorneys, but that's a small law firm in comparison to what we were doing. We were taking on huge defendants with nearly unlimited resources, with dozens of attorneys that were just focused on that case against us. And they had hundreds at their disposal. And so we're going against some of the largest law firms in the state of North Carolina and some in the country. And we're a small group with an attorney who's got a handful of months out there. Now, I was on a trial team with Marvin and another attorney who had a number of years' experience as well. And the 3 of us together were the only 3 who stayed the entire time. The other 2 attorneys would come on occasion here and there and assist, but they had other responsibilities back at the office. We had other cases that were going on. And so, so Marvin and I and the other attorney, Ted, were the 3 that were there day in and day out. And it was, like I said, what an experience that kind of led me into the path of handling larger cases and big cases as my career went forward. That wasn't just that was an opportunity that I had with Marvin. It was not, that result was not the biggest result we had, but it was the biggest case, meaning the workload that went into it and what it meant to take that case to trial. That we were working for all 100 and some people that were injured in that bridge collapse, not just the family that represented on that particular day, those 9 weeks in court. It was all our other clients. It was all everybody else's clients. And so once our case was tried, once we got a verdict, the other cases just settled after that, and we set the benchmark for what the value of these cases would be. And so it was a tremendous responsibility, but it gave me confidence I probably shouldn't have had it at 25 years old in the legal field, but it did. It gave me a tremendous amount of confidence. And we had other large cases, and so dealing with very large firms, and it just kind of gave me the mindset that we can do this, that they are no better than we are because they have, penthouse suites at the downtown Charlotte, or they have, hundreds of lawyers, or they went to Harvard or Yale or wherever it may be, that we can handle cases against just about anybody.
It seems like that's kind of been a theme throughout your entire career, in that I feel like you, being a personal injury attorney, doing medical malpractice work, I feel like doing plaintiff's injury work, you have had an opportunity to go up against some of the best lawyers from some of the best firms. And it seems to me, with my background being in family law, watching you, it seems like it's always a David versus Goliath type situation where the underdog, you have an injured client that's been injured substantially, and they're seriously injured. They need help, and they're fighting against a big opponent. It seems to be a recurring theme. Not that every case is like that, but you get to go up against some of the best and the brightest. How do you charge in there into the courtroom with those people? I mean, I know you've done it for your entire career, but that's a pretty special thing, because I think it's easy for attorneys, not just young lawyers, but any attorney, to get intimidated when you're dealing with a large firm that's got unlimited resources, tons of attorneys. You see, these Ivy League school graduates.
It started with Marvin. Marvin would walk into a room, and we had so many opportunities to have these conversations about how you act, what you wear, how you portray yourself. And Marvin would walk into a room, and regardless of who was in the room, Marvin was convinced he was the best attorney in the room. And whether he was or whether he wasn't, he believed he was. And that gave him an air of confidence that, I was a sponge for him. And whatever he could give me as a tip or a trick, I would take it. And so when I was involved in those large cases, not just the bridge collapse, but the subsequent cases that we worked on together, he had so much confidence, it was contagious. That it was, I always felt the same way, that me being with him, we're the best attorneys in this room, regardless of what room we're in. And that kind of bled over to when I eventually went out on my own, that I know that I'm going against attorneys that have gone to more prestigious law schools than I attended, or that work for really well-known defense firms, and that were highly recruited from law school, and that they could have gone to work for judges and clerkships and all sorts of wonderful things that they did to build up a resume. But at the end of the day, he made a comment to me. He said, it doesn't matter if they went to Harvard, Yale, Campbell, Ohio Northern. We're all counselors on equal playing field in a courtroom. And that's the mindset that I have going in. And you're right that in the cases that we take on, they're big cases, complex cases with lots of money at stake. And the defendants in those cases have nearly unlimited resources. With every case we have, the vast majority of them, there's an insurance company behind the scenes. They're calling the shots. Billion-dollar industry. The insurance industry is a billion-dollar industry, and they've got tons of money to protect their brand. And so it is a David and Goliath. But when we're taking on those cases, I don't see them as Goliath. I mean, I always feel like I have the advantage in every one of those cases. I've picked the case. I've chosen the clients to represent. I've established the facts. We're the ones in control in plaintiff cases. And so I don't look at it from that perspective. And that came from early on. Had I gone to a different firm and had I had a different experience, it may have changed my mindset a little bit. But from the very first day, we were David going against Goliath. But nobody in our office ever felt that way. We always felt like we had the advantage. And honestly, that came from Marvin.
This might be a good time for you to tell us a little bit about Marvin.
Anybody who dealt with Marvin back in the prime of his career, and even towards the end of his career, would have one common theme about him. He was the consummate professional. He was a professional through and through. You would never see Marvin lose his temper. You would never see Marvin raise his voice, scream, yell, in any situation, whether it's in a courtroom, in the office, or personally. He kept his calm all the time, and he was meticulous down to his fingernails, to his hair, to the suits that he wore. There was a uniform, so to speak. Unlike me, he had a wonderful head of hair that he was able to keep his entire life. But he had a mindset, and his mindset I still use to this day. He said, "We wear blue, we wear gray. Those are the only suits that we wear. You wear black if you have to go to a funeral. Blue and grays all the time. Your ties will be a solid theme color. You're not going to have splashy ties. You're going to have any print that's on your tie will be a small print. We will wear red, green, blue, and on the occasion, yellow. And there are certain times where we're going to wear those outfits and those ties." We were involved in a trial in Pitt County, and it was an insurance defense trial. It was an insurance case. It was a bad faith. It was not your typical personal injury case where someone is involved in an accident and they're injured. It was a contract dispute against an insurance company. It was an employee or former employee suing his former employer based on things that we thought were bad faith. We tried the case for several weeks, and we had an honor to try that case. And one of the large defense firms actually had the case originally and wanted Marvin to try the case. And so we brought the case out to Pitt County to try it in Pitt County. And so it was one of those experiences where we're in front of our local Pitt County jury. And most of our cases were not local. Most of them were all over the state. And so we got to come home and sleep in our own beds, and it was a nice experience for us. But we tried the case in Pitt County, and we had a tremendous verdict, and we had a wonderful jury. And at the end of the case, as we did with every case, and we still do, when there's a jury trial, or even there's a bench trial, we go and talk to the trier of fact, the jury or the judge, and say, what did you like about what we did? And how did you get to the verdict that you've rendered? What did we do wrong? What did we do right? What did you like? And there was a woman on the front of the jury named Mrs. King. And Mrs. King and I had tons of eye contact the entire trial. And at the end of the trial, I walked up to Mrs. King and I said, "Mrs. King, thank you for your service. Thank you for the verdict that you rendered in this case. What did we do that led you to render such a tremendous verdict for our client?" And she was a very short woman, and she leaned over the jury rail and she grabbed my tie and she said, "You wear the most wonderful ties." And it opened my eyes to a couple of things. One, Marvin knew what he was talking about in the way you present yourself in court. Okay, the clothes that you wear, the personality that you portray, that was really important. But it also showed me sometimes how jurors, they rely on things that aren't important to render their verdicts. But Marvin was just, again, a wealth of information. He wore his blue and gray suits, and he was pretty regimented about wearing his blue and gray suits. I mean, to this day, I'm the exact same way. You open up my closet, and there are a line of suits that are blue and gray and white shirts. And he didn't wear anything other than white shirts and blue and gray suits and his solid color ties. And I'm very regimented about what I wear, and that comes from him. And personally, he had lots of things that he enjoyed outside of the law, which was important, and that kind of turned me into another side of Marvin. He was very much into his dogs. He ran field trials with his dogs, and he would travel all over the place with his dogs, and he had a true love for his dog that most of the dogs would come to the office regularly and visit us, and so he had things that he could go and do that were outside of the office that kept him grounded, kept him not so focused so much on an everyday business aspect, but gave him an opportunity to do other things. And he was really about his family as well. He had a tremendous family. He had 3 children himself, and it was a family man. In fact, his son Marvin worked with us as well at the firm before he eventually became a judge. And so it was a tremendous learning experience. But he was always a professional. you and I have tried cases together, and some of the clerks have made comments after the cases about how my tone is very calm when I'm cross-examining witnesses, and I got that from him, because that was his take, that when you're presenting a case where it's not emotional, we stay calm. We stay calm. Even if you know your case is going downhill, things are not looking good, you stay calm, because there's a jury watching everything that we do. And at the end of the day, they're looking at your client, they're looking at the attorneys, they're looking at the judge, they're looking at each other. They're trying to read what's going on, because it's a quiet atmosphere for the jurors. They can't talk to each other. There's nothing they can really do until the case has been handed over to them when the attorneys are done. And so we know they're focused on every detail that's going on in that courtroom, especially us. And so we don't want to be the attention. We don't want to wear the loud tie or the crazy socks or something like that somebody's going to look at and say, I don't like that. You don't want a juror to rule against your client because they don't like your ties or they don't like your
Sure.
crazy socks, or
Right.
you wear a suit they don't find very professional. And so one thing that Marvin and I can say, and I think anyone who knew him can say, he was professional. And that was the way he carried himself all the time.
You've shared with me as well that he was also a business, very business-minded and entrepreneur, that he also did other things other than just practicing law.
Marvin, unfortunately, I'd been with him a handful of years, and he got sick, and it was at a difficult time. Anytime you get sick, it's a difficult time, but we had a lot of things going on in the office, and he got sick, and he wasn't able to be around as much in the office as he had been in the past. And so what I'd learned about was everything else that he had going on, and it amazed me how devoted he was to his family and to his dogs and to the law office. But he had this whole other side of him that I didn't know about until he got sick, and I just kind of learned about it because he wasn't in the office all that often, and I would go see him at his house, and we would sit down in his back patio and we'd talk. And so I learned a whole lot about other things, and he had tons of real estate. There was a shopping center that I frequented when I would go to the beach, and he had a role in that. I mean, it was so much I didn't know about him that I didn't get the opportunity to learn, but he did have he diversified his life. He had his law office, he had his fun, personal, his dogs, his wife, and his family, and then he had a whole other side of the business that I really didn't know much about until later on when I learned he had so many real estate holdings, and he had a tremendous number of properties in Pitt County and surrounding areas, and he owned places at the Crystal Coast in North Carolina, and it was just phenomenal what he had done with. And again, that was something that I never saw of him on a day-to-day basis, but I learned as he aged and as he became more and more sick, just more about him as a person. In that respect, that he had all these other things going on that I didn't see as an attorney.
So it sounds like you had this tremendous start with Marvin, and you all had a bunch of big cases during that time. Talk to us a little bit about, I've heard stories, about Marvin turning down settlement offers and how keen he was on taking things to trial. And I know that when, from my involvement in some of the big cases that you've handled, we've had those conversations about, okay, we've got, pretty significant offer on the table now, millions of dollars that are being offered to us to resolve a case. And we've gone through that internal dialogue about, the pros and cons of taking the case to trial. Talk a little bit about his tendencies in terms of whether to settle or go to trial, and how you think he arrived at those decisions.
Marvin was very wealthy, and Marvin had, again, I didn't know at the time, had other interests and other income coming in. We were in trial in Pitt County, and the late Judge Everett was our presiding judge. And we were going against an attorney who came into the courtroom thinking he was the the brightest thing ever. He was a Harvard grad. In fact, he told the jury that he was a Harvard grad. And Marvin never blushed, never flinched, never did it, never showed any sense of concern whatsoever. We tried the case for a handful of weeks. During the time when the jury was deliberating, the judge was in the room, the other attorney was in the room. The other attorney had no real experience with Marvin as a trial attorney. This was the first time they'd ever had a case where they'd tried. And one thing, if you knew Judge Everett, you knew he could tell a story. And so Judge Everett was telling stories about Marvin because he had been a judge while Marvin had been practicing for years. And he said something that sat with me, that stuck with me. And you could look over at the other attorney when it was said, and it was almost a crushing blow to him before a jury had even come out. And he said, the other attorney's name was John. I won't say his last name. But he said, John, I want to tell you something about Marvin. Marvin has left more money on the table than most attorneys will ever make in a lifetime. This is where he makes his living. And what he was telling John was, you may be a Harvard grad, but Marvin turns down settlements all day long to get them into this courtroom because this is where he makes his living. And in that case, the jury returned a verdict of an enormous amount, more than we even fathomed that they would award, more than we even asked for. It was a tremendous verdict from that jury. Incredible. But what it said to us and what it said to John on that day is that Marvin was not afraid to go to court. And the fact that he had turned down money didn't mean that he didn't earn a lot of money in court, that he was confident in going to court and getting better than what they were offering. And so that's kind of been what, the mindset that we like to have as plaintiff attorneys in general. We don't always have the ability to turn cases down or turn money down for one reason or another. But that was something that when Judge Everett made that statement, I looked over at John. John realized at that point that he may not have been following the trial like he thought he was and following the jury like he thought he was. He showed concern for the first time when he realized that Marvin made a living in that courtroom, not, settling cases and not taking cases forward. And so I think he realized for the first time, oh gosh, this might be a problem. There's a reason he didn't accept our settlement offers. There's a reason he didn't agree to resolve the case at an earlier stage when we offered him money.
We've seen cases in our office where, we signed a case as a brand new case, and there were offers forthcoming immediately. And sometimes, seven-figure offers. And I've noticed that for a lot of law firms, it would be very tempting to say, we've been offered $1 million or $2 million or, $3 million, whatever the case may be, to resolve the case right now. And we've only been in the case for, a short period of time. And I've noticed that one of your talents is really being able to gauge, what do I think the case is worth, and how far can I push it?
As a plaintiff attorney, you have to know how to value your case. And the way you value your case is what you think, based on your experience, a jury is going to award. And you're valuing the case based on that aspect versus how likely is it that they're going to award that money and how expensive is it going to be to actually go through trial and that aspect of it. And so when we go through, as much time as we spend on these cases and we learn about all the details involved, and we do focus groups, and we can talk about that at some point, but we get an idea of what a jury is going to do, and we feel very confident about that number. And unless something comes up that we don't expect, we're going to stick to that number. And they're going to either get to it or we're going to go to court. And so in those cases that you've talked about, one of the cases in particular that I can recall, it was a very tragic wrongful death case. And we met with the family. We met with the family within days after their daughter had passed. And they were in shock, still in shock. But they didn't know what was happening. And they were getting calls, and they were getting all sorts of things that were just happening too fast for them to digest. And so they retained us as their attorneys very, very early on in the case. We were recommended by a family friend to get involved in the case. And so we got involved in the case. And I contacted the company who was responsible for her death. They immediately assigned a defense attorney to the case, well respected in the state of North Carolina, and worked for a very large firm, hundreds of lawyers. Again, what we're used to. And he called me and he said, Harry, I think we can get this case resolved. I imagine the family wants to close this case as soon as possible, and we're willing to offer you $1 million to resolve this case. And I spoke to him on the phone. I won't call him by name. And I said, I appreciate that offer. I'm trying to be professional again. I said, we're not at a point yet where we can talk about money. And I don't think that's the value of this case. So let me do some work. Let me do some investigation. Then we can talk again about the value of this case. And he called me back a couple of weeks later. And he said, we can do 1.5, but that's all that we can do. And it's not going to get any better. The things aren't going to change. We've already done the investigation on our end, and so we know what happened in this case. We know all the facts of this case. And I went and talked to you, and I said, they put 1.5 on the table. And you said, what do you think? I said, I don't think the case is worth that. I said, if I can prove what I think I can prove, it's a $5 million case. That's the value if I can prove what I think I can prove.
I remember that conversation.
And I said, it's going to be a chore to get to that point, to prove it. But I think it's there, but it's going to require a lot of work to get there. And you gave the encouragement to let's do it. Let's see if we can prove it. And so we turned down $1.5 million. Now, I can probably say with some certainty, I bet there's less than 1% of attorneys around this country that have ever had $1 million case. I've been fortunate enough to have several over my career. But when you're offered $1 million, that's a lot of money to turn down, not just for yourself personally, for your firm, but for your client.
Sure.
Most importantly, that client who in this situation they had lost a daughter. They had lost a 20-year-old daughter. And no amount of money was going to change any of that for them. And so it wasn't about the money for them. It was about finding out what happened. And could we have told them to take the 1.5? Absolutely we could have. And they would have trusted us because they trusted us as their attorneys. But we thought there was something behind this story that we didn't know yet. And so we litigated that case, and we pushed it fast, very much faster than most cases go through this process. You file a complaint, you have an expectation that in a year and a half to 2 years, you're going to be in trial. We filed in a smaller county with the intent that we wanted to go get it pushed fast. The larger the county, the more of a caseload they have, the slower that usually works, with the exception of some counties. But we filed in a smaller county. We wanted a fast court date. And so a fast court date's a year, essentially. And so we got that fast court date. But in that year, we worked our tails off to uncover information that I thought might be there when I first read the accident report. When I read the small paragraph that was written by the police officer about how the accident happened, the time of day that it happened, the location that it happened, I thought to myself, there's something extra here if we can prove it. Well, as you know, we went to mediation on that case. And of course, they continued to offer their 1.5 throughout the entire litigation. And I kept telling the attorney, that's not going to do it. That's not going to do it. And we finished the last deposition in the case, where I took the deposition of one of the vice presidents of the company. And it wasn't until the last 5 minutes of that deposition did we get to the information that I was trying to prove for that entire year. And when we got there, I looked over at the defense attorney, and I knew right there we had it. Well, we went into mediation, and we were disappointed. We were arguing really big numbers. $5 million was what we wanted in that case. That was the value that we'd placed on that case. And I remember specifically, we were downtown Raleigh. We were up in one of the high rises on the top floors, and in fact, we were the only ones there, still there. It was into the evening.
Yeah, that's right. It was a Friday afternoon, beautiful day outside, a really nice building in downtown Raleigh, just exquisite finishes and the kind of place it's very wowing when you walk into one of those big firms like that and you see the marble floors and the walls are made out of marble and they've got these conference rooms that look like aquariums, like you're looking in a fish tank watching people inside the fish bowl, so to speak.
Yeah, it's impressive. Those firms, they make a lot of money. They're well
sure to
known.
have that kind of an office space. It says a lot that they're spending considerable amounts of money just every month on maintaining that building.
Yeah, they're impressive firms. Don't get me wrong, and their attorneys are good. I mean, they are very good at what they do. In this particular case, from what I remember about this mediation, they got up to $3.5 million, which is a significant amount of money for this family. It provided closure. It put this working family into a situation where they honestly didn't have to work. They could have lived where they were in their lives and where they were financially. They could have just walked away. They weren't going to do that because that's not the kind of people that they were. They had to work. They needed to work for their own personality and just to stay calm essentially after this tragedy. But we all packed up. We packed up, and we were ready to walk away. We were walking away from $3.5 million because we had put $5 million on the value of this case.
And I remember throughout the mediation, we never floated $5 million out there. We were always projecting a higher number, and and we started very high, as I recall, and yeah, they were at 3.5 million when we thought we had reached an impasse. And I remember that we had a conversation in the hallway about, I guess let's go home. Let's drive home and start our weekend. I remember I was headed to the beach immediately after that, driving from Raleigh, and we talked about, I think we're done here, and we packed up our bags and we're ready to leave.
We were, and you're right. We did not forecast to anyone that $5 million was the number. And I'd worked with this law firm in the past, the opposing law firm. I'd worked with this mediator in the past, and the mediator is hands down, in my opinion, one of the best mediators there is in North Carolina. But I also know how he works, and he's very, very good at what he does.
Very, very intelligent, and nothing gets past him. And I think you thought if he knew where we wanted to end up, he'd push us lower.
He would, and he's very good at that. He's very good at pushing you lower than you want to be. So all along, we were projecting to him that we wanted over 7.5, $8 million.
I think it was 7.5 was kind of where we were at when they were at 3.5. We were at 7.5.
And so we did that intentionally to create that bracket of 7.5 to 3.5. We did that, and as we had already packed up, our bags were packed. We were almost leaving the conference room, and the mediator came in and said, I think this case should settle at $5 million. And at that time, I said, give us a minute. And we met with the family, and we talked to them, and that was the number. That had been the number all along. That had been the number from the second week into the case, and that never changed. We proved what we thought we could prove. And
I don't know candidly if we had ever had that number floated to the family or not. You would know better than I, but I know that you always are setting expectations, on the low side and always hoping to exceed expectations. So, but I also know that in that instance, we had clients that were just such good clients. They trusted, our advice and were going to defer to us. At the end of the day, they wanted to know what we thought.
Yeah.
And
every case is different. Every client is different. And some clients don't want to be involved in those kind of decisions. There's a bigger issue to them, whether it's just a closure on the case or finding out what happened or whatever it may be.
Or fairness.
Justice, as
Right.
we hear frequently. And so, and in that situation, I hadn't told them the number because I also didn't want them to be disappointed. Meaning, if we got into mediation and they never got to that number, then they would walk away disappointed, and they'd had enough difficulty over that last year. And I didn't want them to think that the defendants in the case did not respect what happened to their daughter. And I was fearful that if we went into mediation and that they had a number in their head and we could not achieve it, then it was a loss to them. And I'd rather have not done that. And so what I wanted to do was figure out where we could be. Could we get to that $5 million mark where I would recommend to them that we resolve the case? If they didn't get there, I would not recommend that they resolve the case. And that's where we were at that juncture.
That's right.
So
that's right.
When
it was close to 5 o'clock on Friday, and I remember everybody was leaving the firm that we were at, the defense firm. All the employees were walking out the door. They were locking up. It was time to go home.
Yep. And so when the mediator came in the room and said, I think the case should settle for $5 million, we sent him out. We spoke with the family. We told them that was the number, that if it was going to settle for that number, today was a good day for that to happen. Because this mediator, knowing how good he was, there's a chance he could get them to do that in another room. And so we brought the mediator back in. We told him that today and today only, they could resolve the case for $5 million. He went back into the other room. And if you recall, the people in that room did not have the authority to offer that amount of money.
I do remember that they had to make a call to the
CEO,
to the CEO of this massive corporation that was, out of state, and he was gone for quite some time. I want to say it was like an hour and a half or something, but it was.
Yeah.
I remember we had a sense of optimism that at least this number was brought to us by the mediator, and that he would go work the same magic in the other room if he could.
That's
and
right.
Of course, they didn't have authority, but
they
we
did.
waited.
But I want to say it was maybe 7 o'clock, 7:30 at night. They got the call back from the CEO who gave them the authority to resolve the case at the number that we wanted all along. But I think the point of that story too is we were ready to walk away from millions of dollars because we had put a value on that case, and we had done what we thought we could do to prove that case. And so just like Marvin, pay me my number or I'm going to trial. That's where we were. Pay me my number or we're going to trial. And they paid our number. And so, I mean, it takes that kind of attitude, though, in order to get big numbers. You have to be willing to go forward. And if they're willing to pay your number, there's no point in going forward to trial because they paid your number.
Sure.
And it happened in another case prior to that one as well, where we mediated the case, and it wasn't quite as large as that one, but we mediated the case, and we had a number, and we weren't moving, and we stopped negotiating. We just kept saying, this is the number, this is the number, this is the number. And they kept moving up higher and higher and higher, and they finally got to that number, and the case settled. But we didn't budge. We kept going forward to trial. We're going to trial, we're going to trial. Get the trial scheduled, we got the trial scheduled. Days getting closer to trial. They wanted to negotiate. We're not negotiating. This is our number. Pay it. And eventually they did. And so, times have changed a little bit too. Insurance companies are a little bit more savvy than they were back in the late 1990s and early 2000s. And I think they realize what juries can do if you go there. And so I was told many years ago, I had a federal court case and that was in North Carolina, and it was going to Alabama and back and forth, and the Alabama federal judge said to me, He said, no civil case should go to trial. He said, if it does, somebody made a mistake on the way they value their case. And that made sense to me because, you know, no one's going to jail in a civil case. Okay, the only thing we can do is provide compensation for our clients. It's about money. I can't do anything else other than that.
Right.
And so if you've litigated the case and you've done all the discovery and you've done all the depositions, everybody should know what the testimony is going to be. So one of you, if you can't get it resolved, one of you didn't value your case correctly. And so it made a lot of sense. And so, you know, we pride ourselves at our firm of valuing the cases right. And if they have to go to court, they go to court. But, you know, we've been very successful in being able to value our cases and getting the money that we want.
How did you get into medical malpractice? When did that happen?
So when I was with Marvin, we had a medical malpractice case, and he had not done any historically. We were brought into a case by another firm, which happens frequently when I was with him. And to this day, it still happens with me. But we got into a medical malpractice case, and by that point in Marvin's career, he was much more of a big picture guy, and that I did a lot of the legwork leading up to a trial. And so I had to learn everything about the medicine so I could teach it to him so we could try the case together. And so I got into it. I really started to enjoy learning about the medicine and going and doing the depositions and questioning doctors and that sort of thing. We tried the case, and we ended up with a hung jury. A hung jury is when the jury cannot make a decision, and they can't rule in your favor and they can't rule against you. And so essentially that means it didn't really happen. You got to try the case again. Well, we ended up resolving the case after that. But I got my first taste of doing medical malpractice work. And I asked him, I said, do you mind if we take on others? And he basically said, no, but you're handling it. And I said, okay. So the next case that came around was a prostate cancer case. This gentleman out of New Bern had been diagnosed with prostate cancer and was late stage. And we believe that his primary care provider had missed many opportunities to catch it early on. And he had heard of Marvin. And so Marvin agreed to represent him, but saying to me, Harry, you're handling this case. And so I met with the client, and we agreed to represent him. And I had worked on that case for a considerable amount of time while Marvin was sick. I think I mentioned that earlier, that he became sick and got to the point where he couldn't practice anymore. And but when I left Marvin, I'll talk about that in a moment, that case came with me because I had done all the work on the case, and Marvin allowed me to take the case with me. And so I had bonded with this client. He came to the firm because of Marvin, but I had bonded with him, and I had done all the work on his case. And that client ended up passing away, and Marvin ended up passing away before the conclusion of the case as well. But it really got me interested in medicine. I had no desire ever in my life to be a doctor, none, still don't. But it got me interested in medicine, and it was something I kind of picked up on as we were going through. I could understand the terminology. I understand why they're doing what they're doing. But I also realized there aren't many people doing this kind of law because it's pretty complex and it's hard. And there are so many laws in place to prevent you from being successful in these cases. And so a lot of attorneys who do personal injury work don't also do medical malpractice work. It's extremely complicated. In our personal injury cases, look at a car wreck. When you can easily talk about how a car accident occurred, and when it comes to the medicine, you rely on the doctors who treated the patient. You don't have to know that much about it. You have to know generally here and there, but you allow those doctors to educate the jury on what the injuries were and why the patient had to receive treatment and so on and so forth.
And there's a tremendous amount of competition for those motor vehicle accident cases as well. I mean,
there are
a saturated market in many places Many parts of the state are oversaturated with personal injury attorneys that want to be handling these motor vehicle accident
Absolutely,
cases.
absolutely. And so I saw medical malpractice as one of those areas that, one, I liked doing, but two, there wasn't a lot of competition. And I also knew that there could be pretty sizable results in it in complex cases. And so it allowed me to do big cases, complex cases, high dollars, things that I'd worked on with Marvin all along, and in a different area, and an area that wasn't so saturated. And I learned that the attorneys on the other sides of those cases, the defense attorneys, were ridiculously good at what they did. They knew the medicine better than the doctors in some situations. They were so well-versed in what they were doing, it was a challenge to me. It was a challenge for me to sit across the table from them and come up with an argument of why that doctor or hospital or nurse or whatever it may be did something wrong based on the medicine that I'm reading. And they were so good at what they do, to me, it was challenging. And then when I'd go back and do a personal injury case, a car accident case, nothing to knock those attorneys because they're good attorneys, but it was easier. It was an easier case to deal with because the complexity of the medical malpractice cases. But Marvin let me take that prostate cancer case with me. Marvin was a tremendous asset, not only early in my career, but as I transitioned to my own firm. He let me take a bunch of cases that I'd worked on, didn't ask for anything in return. His firm was going to no longer exist. He was ill. He was passing away, pancreatic cancer, and it was just a downhill fairly quickly. And so he helped me start my firm. He gave me a place for my office, which was on the other side of his office. I mentioned earlier how the office was separated into two sides with the conference room in the middle. He let me have the far side, the side that I was already on working, but he let us have that side, no cost. He let me have the cases that I was working on, no cost. He paid me. He continued to pay me a salary for a period of time, even though I had started my own firm, just to give me that start. And so even in his last years, he helped me the best ways he could, which was tremendous. And so I took that prostate cancer case. We litigated the heck out of that case, and we got a great result out of that case. And that really propelled us into doing more medical malpractice.
I know something about most of the big cases that you've handled in your career, and we've talked about them at one point or another. Is this the case where you had the guy with the video camera, the camcorder? Yeah, I'm imagining him buying it at Radio Shack because that's probably where people bought stuff like that back at that time. But is this that case, or am I getting them?
No, that you're spot on. It is that case. And so, although Marvin had helped me in giving me a place to have an office for a period of time and to have the case, I was responsible for all the costs and resources of the case. And so when I met with the client early on, I knew it was not going to end well for him. I knew he was going to pass away most likely before the case ended, unless there was a chance that it settled early. I didn't expect that, though.
And he had prostate cancer, and you knew that. And
yeah, right.
This was a medical negligence case that became a wrongful death case.
Exactly. And so I knew he was going to transition. I'd learned about the medicine. I learned about his treatment. I knew what kind of treatment he was going to have. I knew what toll it was going to take on his body and mind. And I realized that at the end of this case, if we ever had to go to trial, the worst part of all of this would have been lost because he wouldn't be there to testify about what he had to go through. And so I went to, whether it was Walmart or Radio Shack, I bought a little camcorder and a tripod. I mean, a small little camcorder, and had a little flip screen on the side of it. And I went to his house, and because that's where I had to meet him most of the time because he couldn't get around because he was into intense chemotherapy, just trying to prolong his life as much as I possibly could. So he couldn't get around, so I would go visit him in New Bern regularly. And very early on, I put a camcorder in front of him. He had a recliner that he would sit in, as a lot of old men have, a recliner, and he had his TV right there. And so I put that camcorder right in front of there, and I said, his name was Larry, and I said, Larry, I need you every day when you get up and you have your coffee or whatever and you're ready to settle in to your recliner and relax or whatever you need to do. I want you to turn that camcorder on. I want you to say the date, the day of the week, and how you're feeling, and then turn it off. We litigated that case for probably 2.5, 3 years. It went on for a long, long time, and Larry passed away. And when he passed away, I would call him regularly and go visit him and make sure he was still doing it, but I wasn't watching any clips or anything like that. I would get the tapes. I'd get the tapes, and I'd keep the tapes. And I'd give him new tapes, and he'd tell me when his tapes were running out or whatever. His wife would tell me his tapes were running out. I'd get him new tapes, and we'd compiled all these tapes. And I ended up watching these tapes, and after he had passed, and it was hours and hours and hours of him doing it, and he did it religiously. I mean, day in and day out, he would open up the camcorder, flip the screen, he would say the date, he'd say what he was doing, how he was feeling. I mean, it was a part of his daily routine. I realized there was no way I could use this in any real functional way because it was too long. So there was a local company in Greenville that did some video animations and things like that, and I contacted the gentleman, and I went over to his place of business, and I brought all these tapes, and I said, I need you to consolidate these down to about 5 minutes. And he said, okay.
These are probably hours and hours and hours of video. I mean, if he did it every day, day in and day out for, 2 years, 3 years, however.
It was just hours. And so the gentleman put it all together, and I told him what I was looking for. I said, he's changed mentally and physically from the time he started until the time he ended. And the last tape was the day before he passed. And I said, I need to see that transition in a short period of time. I need someone who looks at this to be overwhelmed with what happened to him over this period of time. When Larry started, he was a heavy man. He was full head of hair, big guy. He wasn't overweight, but he was just stocky. And that last video, he had no hair. Chemo he'd lost everything. The hair he did have was white as could be, and he had dark hair early on, extremely skinny, didn't recognize him. And he said on the last video, he didn't even know why he was there. He couldn't say the date, couldn't say he couldn't say anything. He said, I don't know why I'm here. At mediation, I played that tape. Now, we had his kids and his wife there, and I sent them out of the room. I said, you don't want to see this. It's extremely emotional. You don't want to see it. And I didn't want them to see it because at this point he had passed. They had watched him go down this path, and so they had come to the conclusion that, not that they had complete closure because the case was still going on, but they had already seen their dad go through this process. But it's different when you see it dramatically like that. I played that video, and the mediator was tore up. You could visibly see that it impacted him. It impacted everybody in that room. It was just significant. And we resolved the case. It was a tremendous result for the client, for the family, for everyone. It's a tremendous result. And we were in the parking lot leaving, and the mediator came, not the mediator, the insurance adjuster came up to me. And he said, the one who was on the other side. Right. He was the guy on the other side who was negotiating the case and the money, who had the money.
For the defense.
For the doctor, that's right. And he said to me, that was the best video I have ever seen in my career. And we did it on a shoestring budget. And it was just something I thought about early on in the case. And again, that goes back to, back to my days with Marvin. You look at the finish line first. Where do you want to end up, and how are we going to get there? And so knowing what the finish line was going to be like, this is a wrongful death case. How am I going to show his suffering? Because that's a part of this. I had to do something. And so that's what we came up with to do that.
So on the recordings, he was to say, what, the date, was it the time or the date? I know he was supposed to say how he felt, to give the date and how he felt that day.
I wanted him to give the date, the day of the week, and how he felt. And the reason why I wanted him to do it that way, I knew at some point he was going to be unable to know the date. He might know the day of the week, but he wouldn't know the date. Or he might know the date, but not the day of the week. And then at some point it was going to get worse where he didn't know anything. And I knew that by meeting with his doctors, learning the medicine about what he was going through, knowing that it was terminal and there was no recovery for him.
Did he go through chemo and radiation and all that kind of stuff?
He went through everything, every experimental thing he could find. He went through it. And I had met with his doctors at Duke, his doctors in New Bern, and we all knew, and so did he. We all knew it was inevitable.
Sure.
And so it was knowing that it was inevitable. How are we going to deal with that? And I'll tell you one thing about Larry. He was angry, and he wanted the case to go forward. And he always wanted to go forward. He was upset. He had been seeing this doctor for 30 years. 30 years going in and getting physicals. 30 years doing all the things he was supposed to have been doing to stay healthy. And we realized the doctor had not been doing the things that he was supposed to have been doing during those physicals to check for prostate cancer. And had he been doing those things, it was an easy fix.
He could have caught it. If he caught it sooner, he would have
been cured. Completely cured. And so he ended up passing away in his mid-60s from prostate cancer. He was an accountant in New Bern. He made a good living. He not a great living, but he did well. And he had a nice house, and he had tons of pastimes that he had to give up. But it was inevitable what was going to happen to him, and it was planning for that. And Larry knew that. I mean, he knew while we were doing what we were doing. He absolutely knew that he was going to pass away before the case was over, and he was adamant that his family continue the case after he passed. He was adamant that we get everything that they had, or we go to trial, and so that's what we did.
So I know you handled a big case. Well, I guess the first case may have been, a smaller case or an average size case, but I know you uncovered a lot of other cases that were in existence dealing with dental issues and Medicaid. Tell me a little bit about that. I found that to be a really fascinating case, and tell me about that one. How did that come about?
So there was a story that led us up into that. During the days working on the bridge collapse, I met a number of attorneys around the state. One in particular who became a good friend, and he had another case that he was working on. It was a case that involved a wrongful death situation, and he had called Marvin to assist with the case. And at this point, Marvin was sick, and Marvin couldn't assist, and so I took over that role, and I did all the legwork on the case. And we took the case from essentially they'd offered, I think, this attorney $100,000, $150,000, and on the brink of trial, they paid our number, which was just shy of $1 million. And so we worked really hard on the case. I then left and opened up my own firm, and this attorney had called me and he said, "Look, I know you didn't get any money out of that case because you were working with Marvin at the time, and he said, I really respect what you've done, and I know you're starting your own firm right now. There was another attorney out in the western part of North Carolina that just retired and gave me a bunch of files, and I really don't have time to go through them. They're personal injury files. You want to come over here and take a look at these, and any one of them that you think is something you want to pursue, we'll call the clients and we'll go ahead and get them on board and see if that's okay, if you want to handle that." And so I said, sure. And so I spent 2 or 3 days and went out to his office and stayed in a hotel and walked into his conference room and saw piles and piles of paperwork, all these files. And it was just, it was daunting to look at all that and to read all of that to figure out if there were any cases that I wanted to take.
So he wanted you to comb through those files and determine if there was anything that you thought was worth pursuing that you'd be interested in handling yourself.
That's exactly right. And And he wasn't going to take them. I mean, anything I didn't want, he was going to take them, send them back to the attorney and say, sorry, we can't help you on those. And that attorney was closing up his shop, and so he was just, it would go someplace else, I'm sure. So I looked through all these files, and I took 3 cases. 2 of them were car accident cases. And one, the file was less than a quarter of an inch thick, just maybe 20, 25 pieces of paper in it at most. And it was a dental malpractice case. Now, I had never done dental malpractice. I had done some medical malpractice by this point, but never had done dental. But the facts of the case sparked my interest. It was a young child who had gone to a dentist's office, and the dentist had said, you have a cavity, and it needs to be filled. And so the home life for the child changed between that diagnosis and when they had scheduled treatment. It's a very sad story for the young child, but his father had left. And when he left, he abandoned the family, and so left the mom there and the child. The mom was not employed. She was a stay-at-home mom. Dad left. He took everything. He emptied out the bank accounts. He just left in the middle of the night, never came back. The child was on his insurance. Well, apparently he'd taken the child off his insurance. And so mom decided she was going to go back to school. She was going to get a degree. She became an EMT. But while she was in EMT, she put her child on Medicaid so he could get medical treatment while she was going through this process. And so from the time that he got the diagnosis that he had a cavity to get filled to the time where he had scheduled for treatment, he was no longer on his dad's insurance. And so he was on Medicaid. And the new dentist said, or this dentist said, I don't take Medicaid. You need to go find a dentist that takes Medicaid. Mom sees all this advertising going on for these clinics that take Medicaid. And so she goes into the clinic, and they take him in. They separate mom from him. They bring him back to the back room, say, Mom, you have to stay out here. It's our policy. Parents stay in the waiting room. We bring kids back by themselves. He'll be fine. There are decorations and cartoons all over the wall. It's a very kid-friendly atmosphere. Child comes back out after hours of treatment, and he has stainless steel crowns all throughout his mouth. And she said, he was here for one cavity. And they said, no, he had multiple cavities all the way throughout his mouth. And so she had called, she was adamant that he didn't need all of that work, and then she found out he had blood coming out of his mouth, and it was a horrible experience for her and for the child. And she had called dozens of attorneys. No one would take her case. This one attorney, I can't remember his name out in Charlotte, agreed to review her case, but then he retires and doesn't do anything with it. And so I take that small case with me, and we call her, and she agrees to for me to represent her. And I said, look, I don't know anything about dental malpractice, but I'm going to research it. I'm going to see what I can find out. So I called the dentist who saw him originally, and I said, tell me about his dental work. And so he was telling me, and I said, did you know that he went to this other clinic and they did all this other work? And he said, no, there's no way he could have incurred all of those cavities from the time I saw him until he went over to there. And so he said, okay. And so we gathered an expert witness or two. He refused to be an expert for us. But we gathered an expert witness or two who also reviewed the x-rays and said there's no way he could have had that kind of work. And so we contacted the dental office, and they wrote us a letter back saying, would we be interested in trying to negotiate this case pre-suit? Well, again, my file is less than an inch thick now, and that's very small for a malpractice case. And so I said, look, anytime the other side's interested in offering money, we're going to listen, because that's all I can do for you is get you money. And so let's listen to them. And so we went to Charlotte, which I thought was odd. We went downtown Charlotte, one of the high-rises, one of the largest law firms in eastern United States was part of this case. And we're up in the penthouse of their suite, and we negotiated, for hours and hours and hours. And it wasn't a big case. No, it didn't settle for a ton of money. And the mediator, when we resolved the case, came back into the room and he said to me, laughing, so I'm not sure if this ever actually came from them or whether he made it up on his own, but he said, they want to know how much it would take for you to not accept any more of these cases. And without even a blink of the eye, I said, I want you to go tell them they couldn't pay me enough not to take any more of these cases. I realized right then that this client wasn't the only one that they were doing this to. It was a lot more. Well, years later, we devoted years to investigating this case. There were articles written in the Charlotte Observer. The newspaper reporter won a Peabody Award for the work, the investigation that he had done on it. We had litigated, 16, 17, 18, 19 of these little kid cases, and it ended up being worth millions of dollars over the whole span of the years. ABC News 2020 contacted us. They wanted to do a story on our clients. They came down and did a story on our clients. It was a tremendous, not only case, an opportunity for us to get some national exposure for what was happening. What we learned was that the dentist who had started this process of over-treating young patients on Medicaid was not from North Carolina. He was doing it all over the country. And we basically shut him down. That our set of cases going forward started a tidal wave around other states around the country, and we shut him down. Completely shut down his practice. He ended up losing. He ended up being suspended, losing his dental license. The doctors and the dentists in North Carolina ended up either losing their licenses or being suspended throughout this whole process. And it started from a file that was about 20 pages thick, and realized it was just a tremendous money-making scheme that these dentists had started, and that led us into doing dental malpractice work.
So it was Medicaid fraud that
essentially,
they were committing. Yeah. Essentially, they were over-treating these children, basically, and a lot of the children were from poor, underprivileged families, right? I mean, they're all Medicaid,
all
right?
Of them,
and they're all underprivileged kids. Talk a little bit about what your understanding was in terms of what was being told to the parents, like, to justify,
Sure.
this excessive work.
They were preying on this population of people. They were preying on a population of people who needed their children to be on Medicaid because of their income level. Okay?
Right, and lack of health insurance. This was a program that they could have some sort of
absolutely
assistance in paying these dental bills.
That's right. And so the parents are doing the right thing. They're taking the kids to the doctor, taking the kids to the dentist, getting medical treatment, dental treatment that the kids would otherwise need. But the dentists were essentially reprimanding these parents, making them feel like they had done bad jobs as parents because the kids' teeth were in such horrible condition. So they convinced them that all this work needed to be done. They convinced them that essentially they were bad parents for letting the teeth get into the condition that they were. In reality, the kids' teeth weren't that bad. They may have a cavity here or there, as all kids do. But we had these dentists doing the procedure is called a pulpotomy. It's called a baby root canal. It's called a baby root canal because baby teeth don't really have a lot of roots. They have very, very shallow roots as opposed to adult teeth that have very long roots. You've all seen them on x-rays, And so they were doing baby root canals on these kids, and upwards of 16 in a single office visit. 16 root canals with 16 stainless steel crowns put on those teeth while the children were awake. These children were not sedated to the point where they were asleep. They were awake. They were strapped down to a papoose board, which is, at the time, an acceptable form of being able to do dental work on patients. The problem that was happening at these dental offices is they were doing dental work that wasn't necessary, and there was no way they could adequately provide enough numbing medication so the kids couldn't feel what was going on. They were doing so much work at a given time, all of our experts said that the kids felt it. They could feel what was going on to a degree because they couldn't give them enough anesthesia to completely make it go away. So it was a horrible experience. But the reality of it from a legal perspective was it was a tremendous experience for these kids and these parents on this particular days. But it was all baby teeth. One thing we've learned about any legal case, it takes a long time to get through a legal case. So by the time we got these cases ready for trial, they'd lost all the baby teeth. And so what we had, for the most part, were really good-looking adult teeth that these children had. And so it was a difficult part for us in order to litigate these kind of cases, knowing that when a jury looks at you and they don't see an injury, remember the tie example. You never know what they look at. And if they look at a young child and say, we don't see anything wrong, the teeth look great. That was our challenge going forward. And so we focused the case not on so much the result, but it was the actions. And we were able to do a tremendous service for these kids. So when you're dealing with an injury case for a minor, minors can't get the money until they're 18 years old. All of our clients were low income. None of our clients' parents had ever been to college. None of them. These children got enough money so that they could have college paid for if they chose to. And we structured it in a way that they couldn't get it all when they were 18 years old. They got it over the course of their late teenage years, early 20s, so that they could go to college if they wanted to. And it was a long time ago, and these kids are older now, but I know a handful of them kept in touch with me over the years, and they did use it to go to college and break the cycle that had been probably instilled in their family for a long time.
What a despicable thing, for any adult person to do, to take advantage of those families. It must have felt really you must have felt a lot of vindication and an overwhelming sense of pride to come in and stop that. I mean, what a horrific thing. I mean, it's kind of like one of those things like, human trafficking or something you hear about, and it just is so, and that's just, one of the worst things that you could think about doing to somebody. And to think that goes on, I know a lot of people, when I talk to them about, medical malpractice in particularly, I come from a family with a lot of physicians. My grandparents were physicians. My uncles are physicians. I have just a ton of physicians in my family, and people say, well, how do you feel about doing medical malpractice? That your firm does medical malpractice, given your background and everything. And I think what people don't understand is that there is an underbelly to the medical profession and to the dental profession, and there are people out there. We're handling very serious injury cases where a lot of times there's been just horrible negligence, and it's not the kind of thing where we're going after a good doctor that just made an error in judgment, or I think that there's a distinction there, and people just don't understand that. There's just a lot of deference given to medical professionals, and I think a lot of them deserve that deference and have earned it. And then there are situations where it is just it's just a different situation.
There are bad apples in every profession,
right? And, I mean, the same thing with lawyers and everything. I'm not pointing the finger at any one profession, but it's.
I have the utmost respect for physicians. What they had to go through to obtain the degrees they did, to what they have to deal with on a day-to-day basis. Some of them deal with life and death on a regular basis, and so I have the utmost respect for them. The reality is, though, there are situations where the way that they practice medicine is wrong. And the way they do certain things causes people to be injured or killed. And that needs to change. They need to change the way they're doing things in order to be able to stop someone else from being injured. had a case many years ago where the woman went for a sleep study. How can you get hurt in a sleep study? That's the first thought, okay? She was given a pill to go to sleep, but she was given that pill early in the morning. She'd already been there for hours trying to sleep that night, but she couldn't sleep. That's why she's getting a sleep study.
Sure.
The technician who was there opened up the narcotic cabinet, took a prescription off the top, a blank prescription, filled out her information, gave her this pill that was to knock her out, and it knocked her out. When the sleep study was over, he woke her up. She has no recollection of this. Put her in the car, sent her home. She fell asleep. She hit a tree, broke a ton of bones. What we realized was this really upstanding clinic had a process of allowing a sleep technician to make a decision of when to give this very dangerous medication to patients. They had no education, they had no training, they had no idea what they were doing other than this pill made them fall asleep and he could do his job when they fell asleep. And so that practice was a well-known, reputable practice, but they did some bad things. And we learned throughout litigating that case that the doctor in charge did not even know that that's what was happening in his own practice. And so not only in those cases do we accomplish compensating our client, but we change the bad acts so it doesn't happen again. We know without a doubt in that case that they changed the way they did things. When we went to mediation in that case, the physician was there, our client was there. I did a presentation at mediation that was a little bit different than I had done in other cases. And I told the story to the doctor of what had happened. And I took out all the names. And I told him that, I said, I want you to think of the story that I'm telling you. And I want you to reflect on whether you think it's acceptable. As a doctor, what's happening here? And he realized that when he heard the story, the way it was being portrayed, it didn't sound good, but that's what happened. We resolved the case for 7 figures, and when it was over, the doctor wanted to come out and talk. And he came out, and he looked at our client, his patient, and he hugged her, and he said, this kind of thing is not going to happen again. And it was that, it goes to show you, there are bad things that happen in medicine, and they're not bad people all the time, but they're bad things that can happen. And part of what our job is to change those bad things.
I think one of the things that you've shown me as kind of being a recurring pattern is that sometimes we see situations where the provider will put their own financial gain ahead of the patient care. And I know we've reviewed cases and been involved in cases where there were multiple procedures when it all could have been done at one time, and it was done at different times so that they could charge double the amount and get that insurance money by doing the procedures on different days, things like that need to change. The patient care should always come first above how much money you're going to make off of it. If it's dangerous to do it a certain way, it makes no sense to take that unnecessary risk just to try to make more money. And I think that is kind of where there has to be some accountability. There
is, and we see that recurring theme, unfortunately. It comes back to insurance companies as well. Insurance companies, they determine how much doctors receive in payouts from claims. They determine all sorts of aspects of this. And so doctors are learning ways to, and hospitals and other providers are learning ways to maximize profits. And sometimes we're learning that it's not safe to do it in that manner. We resolved a case not too long ago that there were practices being done at the dental office that were to maximize the efficiency, in our belief anyway, to allow the dentist to do things that, see more patients than he should have seen in a given day. and it led to a catastrophic result. And so showing the higher ups at those organizations that this is a wrong way to practice medicine is part of our job. It's part of our job to weed out those bad apples and change the way things happen. I don't know of a case that we've taken on where we got a positive result that it did not have an impact on the medical provider to change the way they do things. There is no way, in my mind, any doctor could rationalize doing the same thing again after they had to pay out in a medical malpractice case. So we're changing the way the medical community operates by taking on these cases. Unfortunately, medical errors still are one of the highest causes of death in the United States, and that shouldn't happen.
Harry, just kind of to wrap things up and bring things to conclusion here, I have two other questions I'd like to ask you. And the first one, I know we haven't talked about this, so I'm kind of putting you on the spot here, but where do you see yourself and the practice in 10 years?
I'd like it to come full circle. What I mean by that, I started my career doing really high-end work with someone who was older, who knew what they were doing. And so in 10 years, I see, and he had a team of attorneys underneath him that were decades younger than he was, but he had a wealth of knowledge. I see us doing the same thing, that we have a team of people who are younger attorneys that can use what I've learned from people, not just Marvin, but other people I've been involved with over my career, and teach them what the right way to practice law, and the right way to handle these big cases, and the right way to deal with clients, and to be professional, and to be respectful, and to remain calm. And so that's what I see in the next 10 years, is that hopefully we're able to build a team that can look to us as those older statesmen, those professional attorneys that have a ton of stories to tell and the things to pass on to the next generation of lawyers.
So that's interesting because it kind of segues really nicely into my next question. So I know that you have had the opportunity to mentor some of the young attorneys that have come through our firm over the years. And what advice would you give to young lawyers that have been practicing, let's say, less than 5 years?
I think first you have to be humble and know that you don't know everything. I still don't know everything. I've got many, many more things to learn as we go through this process. You never learn everything.
Sure.
And you have to look to other people to help you, to guide you and where to go. If you don't have that mentor in your office, if you don't have that person to go to run ideas off of, go to the courthouse. There are trials going on every week in every county. We all know who the most reputable attorneys are. Okay, we all know it. Whatever practice area you're in, you know who the top dogs are in your area. When you know they're in trial, go watch them. Go watch them and take notes. Bring a notepad with you and look at how they do their opening. Look at the details of how they sit, how they speak to the witnesses. Look at every aspect of the way they try the case, and then go watch somebody else. And then watch somebody else. And you're going to see what fits your style. You can try to emulate somebody else, but we all have a style that is our own. I mean, I tried to emulate Marvin, but mine's still a little bit different than his. And so if you don't have somebody in-house, go watch somebody else. And then get into court or get into depositions or do it. Don't shy away from it because it's scary. You got to get in there at some point. If you don't have somebody that forces you to go in there to do it, you got to force yourself to go do it. Not everybody's cut out to do trial work. Not everybody's cut out to do litigation, and that's okay. There are tons of different areas of being an attorney that are not litigation. Same thing. If you want to do wills, go find somebody who does wills really well. Go to the courthouse and read how they did it. Law is based off of precedents. It's cases, things that have gone on in the past that set the stage for what's going to happen in the future. It's not the way our law works. Practice of law is the same way. Look at what the folks did in the past and what the older people are doing to show you what, you should be doing and follow them. That's my best advice is if you hang out your own shingle and you're doing workers' compensation or you're doing personal injury or medical malpractice or real estate, find somebody that you can talk to, that you can go watch, do it, because you're not going to be able to figure it out on your own. You're just not. It's not one of those areas of practice that you can just figure it out on your own. You can figure out the law on your own, but you don't know the technical part. You don't know how to present yourself and what people are receptive to.
I've noticed too that you're always really generous with your time. In particularly like when talking with strategy. I mean, I don't think it. I know that people call you often, and ask you strategy questions, not just young lawyers, but sometimes old lawyers, Is that the kind of thing that somebody, you're comfortable with people approaching you if they've got questions about strategy in a legal matter?
I love doing that. I mean, I think that helps me grow too and listen to somebody else. And, what I do is I challenge, if someone calls me, I challenge them to tell me what they think should be done. I'll tell them what I think should be done. We go back and forth and we try to work out, what's the best course of action based on our experiences and what we know. And so I love to talk to other attorneys, whether they're young or old or my age or whatever they are, even different practice areas. I've had the opportunity now to work on employment cases and education cases and things I had not done in my history. And I love talking to other attorneys about how they practice in that area and their areas of law. And I get to relate how the strategies that I implement in my areas of law and how it might overlap and vice versa. And so I think a big part of being an attorney is trying to be generous with your time with other attorneys. We are a profession at the end of the day. That's the way I see it. That's the way I was taught, and that's the way I see it. We are a profession, and we need to be professional with each other. And if at any time another attorney needs some assistance from me or some guidance, I want to be able to give it to them, because if I need the same thing, I'd want them to give it to me. I've had people over my career be willing to give me time and help me when I needed help, whether it's Marvin or other attorneys or, whatever it may be. They've helped me through my entire career. And it's what I see is our obligation to the next group coming along and to anybody else that's in our profession. It's a group of us. And so it takes a lot to be an attorney, and it's not easy being an attorney. Not only is it not easy as a profession, as a job, but it takes a ton of time, and your personal life is impacted by what we do for our clients. The clients come first, and so it's a hard road. And so anytime I can rely on somebody else for some advice or vice versa, I'm going to take it.
Well, Harry, this has been fantastic. It's been awesome talking to you. Some amazing stories that you've been through over your career, and thanks for coming on.
I appreciate it. It's been fun.
Thank you. Thank you for joining us on this episode of Go Big with Gib. If you haven't already, go follow us on social media at Gib Irons. We'll see you next time.